Good afternoon, everyone. This is the Garden Court Judicial Review Update webinar. We're joined by Irena Sabic KC and Matt Ahluwalia, who are going to be making some presentations on very important zeitgeisty issues. First of all, the intensity of review in judicial review cases, mandatory orders and the public sector equality duty. And then I'm going to bring up the rear with some practice points at the end. You'll all know Irena. I'm to tell you that this event is being live streamed and recorded, and the recording will be uploaded to our YouTube channel with the link and slides sent to all attendees. We've left us some questions, some time for questions at the end. And so if you could pop your questions in the Q&A box, we'll do our best to answer them, time permitting. We aim to finish at 2:15. So you'll all know Irena. She's an experienced and highly regarded public law practitioner who's appeared at all court levels. She has a particular focus on cases involving unlawful detention, abuse of power, equality, discrimination, the treatment of vulnerable children and adults subject to immigration control. She sits in the High Court as a Deputy Master of the King's Bench and is appointed as Chair of the Health Service Products Appeals Tribunal. Irena is going to speak to you for about 15 to 20 minutes. Take it away, Irena.
Thank you very much, Amanda, and welcome all to our lunchtime seminar. Thank you very much for joining us. My first task for today is to see if I can share my screen effectively. So I am going to do that now, or attempt to do that. And I will be speaking to you about two broad topics through the mechanism of recent case law. And the first one of those is intensity of review, to examine what the courts have recently said about the different applicable standards and the context within which they arise. And the first case that I want to talk to you about is the case of Refugee and Migrant Forum of Essex in London, otherwise known as Ramsell, and the Secretary of State for the Home Department, and it's there on the first slide. That was a whole-scale challenge to the practice operated by the Home Secretary not to provide documentary proof of lawful immigration status to those whose status was automatically extended by the operation of the Immigration Act Section 3C leave. And most of you in this seminar will know that that is the type of leave that's extended by virtue of a statutory provision when an application was made in time for an extension of previous lawful leave that hasn't yet been determined by the time that the previous leave had expired. So those individuals were and are in a very difficult position given the context of what's now called the compliant environment policy. It used to be known as the hostile environment. Now it's been changed to somewhat better sounding, though no less hostile, compliant policy, whereby those immigrants with lawful leave who have the benefit of Section 3C leave could not show to third parties, for example, landlords, banks, employers, that they were in fact lawfully in the UK. And that was said to be providing obstacles to the enjoyment of their life in the UK and the ability of them to operate in any semblance of a normal life. And the claimant's argument was that by not providing those individuals with a documentary proof of their leave was unlawful on four different bases, two of which are relevant for our purposes. The first was that it was said that the Secretary of State was frustrating the statutory purpose of Section 3C by essentially exposing the wrong people to the wrong denial of their entitlement within a system that was founded on a document-based verification of immigration status. Secondly, they also argued that the decision not to provide documentary evidence was Wednesbury unreasonable, in other words, irrational. One of the critical points for the determination of the case, and the starting point was the applicable standard of review. And in summary form, the main contenders were the Padfield principle, the frustration of statutory purpose, or a Wednesbury unreasonable challenge. In other words, the decision was outside of the range of reasonable responses, which is arguably a much higher standard. And Kavanagh, Mr. Justice Kavanagh, set out a very comprehensive analysis of the relevant case law, concluding that on the basis of the discretion that was in play, the applicable standard of challenge was not the Padfield principle, but indeed the unreasonableness Wednesbury principle. And that was, in main part, because the power itself to grant documentary status did not arise from a specific statutory power, but instead the power came from the generality of the Immigration Act and all the ancillary framework. And the power was such as to exercise ancillary and administrative functions in order to give effect to the powers and functions given to the Secretary of State by the Immigration Act. And so this is really important to note, because the source of the power that's being exercised by the public authority will be, in some cases, determinative of which standard is applied. It's also interesting to note that there were three other aspects of this particular case, which meant that Mr. Justice Kavanagh concluded that the margin of latitude or the discretion afforded to the public body was even greater in this case. The first was that the challenge concerned the field of immigration, and therefore, in the court's view, a similar level of respect was to be afforded to the executive decision-making as, for example, decisions concerning social and economic policy, social security, highly politicized decisions, in other words. The second, and we've looked at this already, the non-specific nature of the power or the discretion that was being examined. And the third, and I think we'll pick this up when we look at the mandatory orders section, the remedy that the claimants were seeking in this case was a very specific and mandatory one. It was, in fact, to obtain an order that would have the effect of compelling the Home Secretary to take a positive step to provide all those on Section 3C leave with the means of proving their status. And it's interesting and important to note the results, but for our purposes today, the focus is on the standard of review, and one can see that from Ramphel, the standard is a very, very high one, Wednesbury, but even within that standard, the discretion that's given to the Home Secretary is a very, very wide one. The result should not be forgotten, because the claimants in this case were able to successfully show that even though the standard applied and the latitude was great, the failure to provide the documentary evidence was indeed irrational, and the claim was granted. The second case that I wanted to bring to your attention is a decision of Mr. Justice Fordham from the summer, the end of August, the case of Fighting Dirty Limited and the Environment Agency, where Mr. Justice Fordham considered the Environment Agency's decision to remove the target date for implementing its sludge strategy. The sludge strategy is a very controversial issue at the moment. No doubt you're all aware of the difficulties that the Environment Agency has had with effectively regulating the water companies' release of sewage into rivers, and this was an issue that was touched on in this case, given that the sludge strategy concerned the treatment of sewage water and its use in agriculture. So there was a very high degree of both controversy and interest in how the court dealt with this. The claimant's case was the failure to include a replacement target date was incompatible with the agency's public law duty to regulate effectively, in other words, act reasonably, and it was submitted that the agency had taken a do-nothing approach. The Environment Agency, on the other hand, said that the starting point for the judicial review was the general standard of unreasonableness and the fact that the claim was an Aarhus Convention claim, in other words, relating to the environment, didn't change the standard of review to a more intense review. It's really interesting to see how Mr. Justice Warden dealt with this for a number of reasons. The first one is that he confirmed the principle that was set in the case of Evans and set out there in the third bullet point on the slide, which is that the environmental judicial review cases could attract a close intensity of reasonableness review, but that the Aarhus Convention, which focused on anything relating to the environment, didn't stand as a rigid test for a uniformly heightened scrutiny. So that principle remains undisturbed. However, what he then said is this, and I've set out his reasoning because I don't think I can put it better than he did there in the slides. The first point that he made is that he says that environmental judicial review cases can attract a closed scrutiny, but there will always be context-specific features which point in favour of or away from heightened intensity of review or a narrow attitude. And he then says that the seriousness of an environmental problem and a publicly recognised necessity for change are capable of pointing in favour of a contextually higher intensity review, so can the importance of the issue. And then he caveats it with, of course, they don't stand alone. But it is important, in my view, to note the emphasis of the judge on the range of factors which include the publicly recognised necessity for change and the urgency of the situation as factors that can affect the type of review or the intensity of review that the court will apply. The second point that he makes is that, and I think this is really exciting actually, is that he says, I wouldn't accept in the context of environment protection a fixed focus on human rights as distinct from fundamental rights, interests and values, where an important individual interest is at stake is only an instance of more intense scrutiny where the circumstances require it. Nor can I accept the characterization of environmental protection as a matter which does not raise issues of real importance to individuals. On an international plane, the lexicon embraces the right to a clean, healthy and sustainable environment as a human right, and he gives a citation to the senior Swiss women case from the European Court of Human Rights, ending with public law protects rights, but also values and interests, including the public interest, and this allows for an ecocentric standpoint, not just an anthropocentric one. Now, this is, in my view, a really significant development in public and environmental law, because there is a clear nod to the environment, to the internationally recognized right to a clean, healthy and sustainable environment, as well as a completely different starting point for examination of environmental judicial reviews, and that is an ecocentric standpoint rather than one that's based on human rights alone. And my view on this was that it's certainly unlikely that this will be the last that's said on the issue, and I suspect that this will form the basis of further development in the near future in terms of how environmental rights are considered on a domestic as opposed to an international field. So then the third point that he makes is that although an Aarhus claim does not necessarily apply a different standard of review, the judge reminds us is that even the public law unreasonableness standard involves variation in the intensity of Wensbury review that reflects the nature of the interest affected. He categorizes that as a cardinal truth. And again, this is really significant because even in cases where there is a high threshold of Wensbury unreasonableness applied, there is no bar to the type of considerations that can be prayed in aid of higher or lesser scrutiny. The last point that he makes, which I wanted to bring to your attention, is that he concludes in the event that this particular case warrants careful scrutiny, which is apt for the environmental protection context. In other words, it attracts a more intense form of review. But then he goes on to explain what he means by that. And he says, I do not accept this is the case where the Judicial Review Court needs more in terms of the strength of the reasons required to justify the agency's actions as reasonable, nor that the context and circumstances serve to narrow the width of the latitude afforded to the agency. And he relies and concludes that the position that was before him did not involve or equate to an imperative urgency. But the reason I think this is important is that in other cases, or in cases that you might have going on, you might want to give some thought to what kind of greater intensity are you asking the court to make, depending on the context of the case. Is it a case where it would be appropriate for the court to look more carefully at the decision, or is it a case where the court will need more evidence, justification, reasoning in order for the decision to be justified as reasonable? And I think it's a useful lens through which to break down what is in fact required by a heightened standard of review, even in Wensbury cases. So, galloping through the duty of candour and looking how much time I've got available, I'm sticking with Mr. Justice Fordham, but moving on to the duty of candour. And I've set out the 10 principles that Mr. Justice Fordham summarised in the case of Police Superintendents Association and Police Remuneration Review, because it is a really useful guide to what is required and what is meant by the duty of candour in judicial review. And before I move on to going through them fairly briefly, given the time, just a note that it's useful to look at the guidance on discharging the duty of candour that is issued by the Treasury Solicitors Department. It's somewhat dated now, from 2010, but nonetheless it forms the basis and informs the principles that Mr. Justice Fordham set out, and there are 10 of them. So the first one is the standard disclosure principle, which is essentially that there is no standard disclosure of documents, and that's perhaps the basis for which the duty of candour applies in judicial review. The second one is the just disposal principle, which is that the test for ordering specific documents or specific categories of disclosure is necessity to resolve the matter fairly and justly. And this really is an echo to the overriding objective, in my view. So if specific disclosure is going to be granted, the critical test is can the court, is the document or the disclosure necessary for the court to be able to determine the matter in line with the overriding objective. The third principle is the candid disclosure principle, which is a well-known principle to most of us. It's what certainly we've considered the duty of candour to involve. All cards are faced upwards on the table, and that involves full and fair disclosure of all the relevant material, and we'll look at what all the relevant material is when we look at the 10th and perhaps the most exciting of the principles. The fourth principle is the information to principles, which is that relevant facts need to be identified in witness statement evidence insofar as they are not apparent from disclosed contemporaneous documents, which means that if documents raise questions about how they fit into the evidential scheme, they should be supported by statements and evidence that's prepared specifically for the purpose of the proceedings. Principle 5, the relevant material principle, sets out 3 categories of documents that are required. All of those reasonably required, full and accurate explanations of all facts, and thirdly, a true and comprehensive account of the way in which the relevant decisions were arrived at. Principle 6, non-selectivity principle, it mustn't be selective. Again, it must include the unwelcome along with the helpful. The best evidence principle is really a reflection on the other side of the coin of the information to principle, which is that it shouldn't just be the witness statements explaining, but if documents exist which show, then they should be produced too. The redaction principle sets out that in cases where there is a concern about public interest immunity, confidentiality, they should not be withheld, but can and should be redacted. The permission stage principle, the duty of candor applies both prior and post-permission, although it is heightened post-permission. And then lastly, the unpleaded grounds principle, and this is where I think it's important to pick up on the earlier points of all relevant material. This is an important principle, and it's one that's potentially wider than many of us thought the duty of candor applied. So it sets out that the duty applies to documents and information which will assist the claimant's case or may give rise to further grounds of challenge which might not otherwise occur to the claimant. In other words, there is a duty on the public body to look at the pleaded grounds, but also to look more widely at the lawfulness of the decision, regardless of whether or not grounds or indeed evidence which can support further grounds would be helpful to the claimant to have sight of. And that's a really important principle that in my view has extended the duty or clarified the full extent of the duty, and which is important to bear in mind. So that brings me to the end of this whirlwind tour of intensity of review and duty of candor. Thank you very much for listening. I will try and dutifully stop sharing my screen and hand over to Matt.
Before Matt starts, I'm going to introduce him. Thanks very much for that, Irena. Matt has a lively public law practice and is happy to accept instructions in judicial review cases. He often advises NGOs as well as individuals and is a regular contributor to LAG's quarterly public law update column. Some of you may know also that Matt undertook a lot of very serious JR work when he was at the Public Law Project. He's happy to accept instructions in public law matters arising from asylum support issues. Take it away, Matt.
Thank you very much. I'm also going to attempt to share my slides without hopefully also sharing all the embarrassing tabs I've got open. So one or two overlapping themes in the cases that I wanted to talk about. And I suppose they all sort of stem from the judgment that we got towards the end of last year in Imam and Croydon. And it's to do with, I guess if you were to give this talk a couple of themes, it would be mandatory orders and the relevance of limited resources, both of which had some application in the Imam and Croydon case. So just as a reminder, Imam and Croydon was about a homeless application in which Croydon had accepted what's called the main housing duty under the 1996 Housing Act. And the homeless applicant was accommodated by Croydon, but Croydon had acknowledged some time ago that the accommodation that had been provided was not suitable for them. And it's important to bear in mind that local authorities have various duties in terms of providing suitable accommodation to homeless applicants in any accommodation offer that's made. In seeking to obtain better, more suitable accommodation, the homeless applicant brought a claim for judicial review, arguing that Croydon had breached their statutory obligations. And it's important to remember that Croydon had accepted and acknowledged that the accommodation was unsuitable. The issue really was, what, if anything, should the court do about it in a judicial review case, bearing in mind that, of course, judicial review remedies are always discretionary. And so the issues for the Supreme Court, as was stated in the statement of facts and issues, were essentially what approach should the court take in exercising that discretion, in this case, whether to make a mandatory order in circumstances where an authority, a public body, is in breach of a statutory duty it owes to an individual. And in particular, what relevance, if any, did a local housing authority's limited resources have on the exercise of the court's discretion, and whether the Court of Appeal below was wrong to hold that budgetary constraints on, in this case, a local housing authority, were not relevant to the exercise of the court's discretion in terms of remedies. And you've got on the slide the sort of key summary points from the Supreme Court's judgment, as summarised in the headnote from the Weekly Law Report version of the judgment. So where a public body has breached a statutory duty which is not qualified, as in this case, by any relevant way, with any reference to resources available, it's not for a court to modify or moderate the substance of a duty owed by routinely declining to grant relief to compel performance of that duty, if sufficient resources are what is pleaded by the defending public body. And instead, what the court should do is ordinarily exercise its discretion by granting the remedy, and should proceed cautiously before exercising its discretion to refuse, taking care to ensure that only to do so where that course is justified, should not make a mandatory order to require compliance where compliance was impossible. But when examining the question of impossibility and compliance, the court does need to balance the need to enforce the law against the impact that such an order would have on the authority's ability to carry out its statutory functions. And the onus in such cases is going to be on the authority, on the public body, to explain to the court why a mandatory order should not be made to ensure that it complied with its duty, which requires a detailed explanation of the situation in which the authority found itself and why this would make it impossible to comply with an order. So you can see, hopefully straight away, you can see the kind of connection there between the sort of evidentiary requirements and also the principles about duty of candor that Irena just talked us through. So it's not going to be enough to just say in the general terms that that resources are an issue and we're short-staffed or we're lack of budget or there's just not the stock that we need. An explanation is going to be required, and that may be in the form of not just more disclosure than one might otherwise expect in terms of primary documents, but perhaps in terms of witness statements from relevant officers at the public body or at the local authority, explaining the situation and explaining to the court why we've ended up where we are. And so what I wanted to do is just expand on some of these themes a little bit and give you a little bit of the context as to how we got here, and also just raise a couple of cases post Imam and Croydon in which mandatory orders were made for non-compliance of statutory duties. By way of background, probably worth remembering another sort of homelessness case, which has some similarities to the situation in Imam and Croydon. Worth just remembering that, of course, this is not a judicial review case it started life as a Section 204 appeal in the County Court. That's Section 204 of the 1996 Housing Act. For those of you who maybe don't practice in that area, Section 204 appeals are almost like judicial reviews of homelessness decisions. You can only bring them on the basis of an error of law, and so the public law principles that you would typically see in a judicial review case do tend to come up in Section 204 appeals as well. So it's very much applicable in the judicial review context. In this case, the family was offered accommodation near Milton Keynes by Westminster City Council. The appellant rejected that offer on the basis of the location primarily, and requested a review of that decision, and then appealed to the County Court when that review upheld the original decision. At first instance, the County Court judge said, as is set out on the slide, that whilst there's no reference in particular to the fact of consideration given to the area, so in other words, no particular reference to the question of location, what the judge at first instance said was that it seems to me almost inevitable that the team must have had regard to all the stock that was and allocated what was the most suitable property available. So at first instance, the judge has given the local authority there quite a lot of leeway. That did not particularly impress the Supreme Court, and in that case, Westminster were criticised for not following the published guidance on how to approach location of accommodation when it's being provided to homeless families, as well as not providing various items of secondary legislation as to how to approach suitability of accommodation. And I've highlighted in particular paragraphs 36 and 37 of Lady Hale's judgment on the importance of evidencing steps taken in these cases where maybe there is a shortage, but evidencing the steps taken to try your best to comply with the duty that's owed. So in homelessness cases, for example, under the 1996 Housing Act, there's an obligation to offer accommodation as close as possible to the borough. So in this case, if Westminster couldn't find accommodation in the borough of Westminster, what they should have done is at least looked for accommodation as close as possible to Westminster. Whereas in this case, what appeared to have happened was accommodation was only offered in the sort of Bletchley, Milton Keynes area, and there wasn't any evidence of attempts to find accommodation nearer. And so the Supreme Court unanimously allowed Ms. Nzola Meso's appeal, partly on the basis of a lack of evidence, a lack of steps being taken to try and comply with the duties that were owed. And so you can sort of see, again, the kind of similar sort of threads running through these cases, and you can see how we got to the sort of Imam and Croydon situation, particularly because the housing crisis has not really gotten any better. But on the issue of relevance of resources, there's a long line of cases in which the courts have held that where you have a statutory duty, resources are unlikely to be a legitimate reason for a failure to perform that duty. Going back as far as Tandy, which is to do with education. And then in the case of Fletcher and Governor of Watton Prison, Secretary of State not entitled to overlook the public law duty by pointing to inadequate resources. In Hotak and Southwark, which is another homelessness case, this time about the approach to assessing priority need in homeless applications. Again, the court very clear that the duty to the applicant is defined in primary legislation in this case, and the fact that the authority may be short of money or available accommodation cannot in any way affect whether an applicant is in priority need. So not so much directly to do with offering suitable accommodation in this case, but just whether an assessment of resources has any bearing on one's evaluation of whether an applicant is in priority need for assistance. And the Supreme Court's very clear that it doesn't. The courts have also said very clearly in at least two cases, at least the two cases that I've dug out here, that a desire to save money, or in other words, having an eye on resources and budgets, is not a justification for discrimination. So, for example, in the RF case, which is to do with discriminatory secondary legislation in relation to personal independence payment. The High Court, as Mr. Justice Mostyn said, that the wish to save, as was cited by the Secretary of State, the wish to save nearly £1 billion a year at the expense of those with mental health impairments is not a reasonable foundation for passing discriminatory legislation. And similarly in coal, which is to do with discrimination in the provision of approved premises for female prisoners. Again, the Supreme Court was clear that budgetary considerations cannot justify discrimination. If a benefit is to be limited in order to save costs, it must be limited in a non-discriminatory way. So you can't use resources as a way of justifying discriminatory treatment. More recently, the courts have taken this into account, resources into account when it comes to assessing suitability of combination in various contexts. In particular, the cases that I've highlighted here, so El Kundi and Bell, both to do with suitability of accommodation. And this passage from El Kundi is quoted in both Bell and in UO and Redbridge. And it's worth having a look at paragraph 132 of El Kundi because it's something that I seem to keep citing in cases that I'm asked to look at when it comes to unsuitable accommodation in particular. And as I say, it sort of goes back to that sort of the principles that we saw in Nzola Mesa about properly evidencing the steps that are taken and why suitable accommodation has not been forthcoming. And as the Court of Appeal said, references to the general difficulties facing housing authorities or the lack of availability of suitable properties may not persuade a court that a local authority has taken all reasonable steps, particularly when there's been a lengthy period of non-compliance or where the accommodation falls so far below any level of suitability that more immediate action might be expected. The facts of El Kundi and Bell are both quite similar in terms of to do with provision of suitable accommodation. UO was more to do with well, it was to do with suitability accommodation, but it was more to do with the assessment of a homeless applicant's housing needs and the sort of relationship between a proper housing needs assessment and suitability of accommodation. But both of them apply and adopt the key passages from El Kundi. And as I've mentioned on the third bullet point on this slide as well, a lack of resources is also not going to be an excuse for not complying with your duty of candor. Again, just to sort of tie on again from Irena's talk. Worth just mentioning that in Montano, what happened was after scouts and arguments were exchanged and after bundles were prepared, Lambeth shared disclosure with the claimant's solicitors very shortly before the substantive hearing was listed for, and without providing an explanation as to why that disclosure was not provided earlier. When the court asked Lambeth's counsel why the disclosure hadn't been provided at an earlier point, there wasn't really, with all due respect, much of an explanation, and it was accepted by Lambeth's counsel that disclosure should have been handled better. But again, without really much of an explanation, and the court took the time to set out in that judgment a sort of short overview of how candor should have worked better in that particular instance, but took the trouble to emphasize at paragraph 80 that a lack of resources is not going to be an excuse not to comply with the duty of candor. And so, yeah, if a local authority or another public body is short-staffed or is having issues with the budget, that's not going to be an excuse for not complying with the principles that Irena has helpfully set out for us. Including, I would add, the duty to sort of to explain, not just to disclose sort of primary source level documents, but also to explain what they mean and how they might apply in this case. So in Montano, there was, for example, very late disclosure of guidance documents that Lambeth used internally, but not really an explanation as to how they might have been applied in that particular instance, or no explanation as to as to previous instances in which the guidance might have been applicable. Montana and Lambeth, by the way, was about an allocation, it was to do with the housing allocation scheme, but obviously very much relevant to this issue in terms of resources. And yeah, I just thought it was quite a helpful sort of illustration that resources aren't going to be an excuse for not complying. Next case I just wanted to highlight was on this sort of thread on the relevance of resources was, again, just to sort of emphasize the importance of evidence. So in Perul, the issue was to do with the failure to provide suitable accommodation under Section 4 of the 1999 Immigration and Asylum Act. So accommodation under the asylum support system. And in this case, again, there was a kind of acknowledgement by the Home Office that the applicant needed to be accommodated in a certain area, but there was then quite a long delay in actually moving her to the area in which she needed to be. And the court was, as you can see from this passage, particularly unimpressed with the Home Office's absence of any evidence on their key points, really, about shortage of stock and what would have been a reasonable time to comply, and so on. And the court quite helpfully set out the kind of evidence that they might have expected to see if the Home Office in this case were going to rely on those points. So if they were going to say, oh, well, there's a shortage of stock, then they would have expected some evidence as to why that was applicable. So paragraph 54, whether the claimant's case has been prioritized in any way and how that might work, how the relevant guidance might be applicable, steps that had been taken in terms of accommodation, records of stock and providers, evidence and explanations about contracts with providers in the relevant area, evidence about third parties and agencies and contractors and so on, none of which had been provided to the court in this case. And so in that case, a mandatory order was granted as well. So again, it's the importance of evidence and the general point that reference to, in general terms, the lack of resources probably won't cut it. And then just to finish up, I wanted to just raise a couple of cases that have come out post Imam Croydon that apply the principles that I've just ran through. So both of these are in the education context, and both L and Hampshire and HXN and Redbridge are to do with failure to implement EHCPs that had been ordered by the First Tribunal. And in both cases, there was quite a long delay in implementing the HCPs or parts of the HCPs. In both cases, the local authority accepted at some point that they hadn't complied with their statutory duties under the relevant legislation, and that they hadn't implemented the HCPs properly. L and Hampshire, I think, is particularly useful because it sets out very clearly the different steps that L and her representatives had taken to try and move things forward before they'd issued. The court also emphasizes in L the importance of speed being of the essence in cases where education is concerned. And indeed, that may well be applicable in other contexts beyond the kind of pure education sort of field. So it may well apply in housing cases or asylum support cases where education is being affected. And considering that speed is of the essence and considering that education was the context, the court took the trouble to point out that all of that was at significant detriment to the child in question. And updates as opposed to actual progress with a timeline and a plan and a kind of set schedule for when steps are going to be taken was not sufficient to satisfy the court that a mandatory order shouldn't be made in both of these cases. The court took into account the delay in both cases. The court also took into account, I think in at least one of them, that saying that it's all the fault of a third party who isn't doing what they're supposed to be doing also won't by itself be satisfactory. particularly where the legislation is clear that it's the local authority that's got the duty, as opposed to a third party or a contractor. So to sum up, I think it's quite an important line of cases that we've now got to sort of fall back on and rely on. I'm certainly seeing more and more of these cases where it's recognized and acknowledged by the relevant public body that something is not right, that accommodation is not suitable, or something is not being done that ought to be being done. And whilst one on a human level needs, can be mindful of resources and the very great difficulties that a lot of public bodies are under, at the end of the day, from the claimant's perspective, it's on us to do our best for our clients. And I think the line of cases that we've got pre and post imam are now quite helpful and quite clear, I think anyway, as to what we can ask the courts to do in these cases where maybe there is an issue of resources, but if there's a statutory duty that's got to be complied with, then we've got the remedy available to us, and the court, we can ask the court not to be too cautious in those circumstances. That I think is me. So I'm going to stop my slides there and hand over to Amanda, who's going to take us home.
Thanks very much.
Thank you.
That was a whistle-stop tour of both of you through some very useful points. My brain's pinging about the possibilities. So I'm just going to wait for Anusha to get my screen, my slides up on the screen there. So here they come. I'm going to be dealing with somewhat more prosaic matters. So consent orders and reasons. So the reasons why I thought it might be helpful to just highlight that now is because when you have a change of administration, sometimes a different view is taken on JRs which are pending in court, and you might get an AOS or a defence or just a letter from if your opponent, if your defendant is a government body, you might get a letter saying, well, we're going to look at this again, we're going to look at this policy, we're going to have another look at this decision. And then the question is, what do? You might be quite far down the road. The starting point is that the court maintains independent oversight of the proceedings. In other words, and sometimes opponents, defendants need reminding of this. In judicial review, there were always three parties in the court. There's the claimant, the defendant, there may be other parties, but there is also, crucially, the public interest. It's also, and this isn't a presentation about declarations, which could be a whole session all of itself, but I did want to flag up here that declarations, if that was the way that the parties are going to go by means of resolving the matter, can't be made without the court being satisfied that the declaration should be made. And so that means that the court has to be satisfied on submissions. There has to be effectively a contested argument. There's quite a lot of law on the circumstances in which declarations should and shouldn't be made by the court, particularly in cases which maybe academics say because the underlying decision in that specific case has been withdrawn. So it's important to recall that it may be inescapable that if you're agreed about what the outcome should be and the matter concerns something which is going to affect third parties, such as a challenge to a policy or an interpretation of primary or secondary legislation, then it's inevitable that the court's going to want to understand precisely the reasons why the parties are agreed as to the declaration that should be made. And that will be done on directions, but it is something that you have to grapple with. Next slide, please. So the other thing to remember is that you might need reasons because you might want to ensure that whatever the public law error was that you were challenging isn't simply repeated in any subsequent decision, and you might want to try and maneuver that through, and that's going to be a process of discussion. But what sometimes defendants don't want to confront is that consent orders are precisely that. They're consent orders. Unfortunately, they're not to be imposed on you by the defendant. And unfortunately, we have some assistance from the CPRs on how and what the court will expect by way of an agreed final order if that's the way that the case is going to go. So the practice direction provides that if prior to judgment being given on a claim, the parties agree the terms of final order, there's some practical stuff there. But importantly, there needs to be an agreed statement of the matters relied on as justifying the proposed agreed order. Now, that means that there has to be agreement, effectively, as to why the court is making the order. But importantly, if that order is to reflect the outcome that your client requires, then you need to be able to identify in that statement and agree in that statement what the error was, and that might be problematic. So that's the close attention that you need to be able to apply, and that's also the point at which you may be unable to reach agreement with the other side and end up in court directions. But that's a helpful direction there in the PD, because of course quite often the defendant will just be expecting you to sign whatever draft they've sent you. So the courts will consider the documents referred to. If the court's not satisfied that the order should be made, a hearing date will be set, and that will include, obviously, if there's a dispute about what the form of order should be. Where the agreement relates to an order for costs only, the parties need only file a document signed by all the parties setting out the terms of the proposed order. And that's important to remember. Next slide, please. There's also some assistance you'll see next in the Administrative Court Judicial Review Guide. I'm glad we've had an opportunity to do this update because, of course, since the article in LAG was published, there have been a number of changes, including that the Administrative Court Judicial Review Guide 2024 is now available. That guide makes some additional, largely repeating, but also helpful guidance on how to make sure that an order put before the court is suitable to be approved. And importantly, reiterates that the open justice principle applies to a determination made on the papers, and the court may have to give consideration to the question whether there should be public access to documents. That's very important to recall, and it reflects what Mr. Justice Fordham said in the Re-LC case, which is cited in the LAG article, and obviously is something which both the courts and parties ought to be increasingly aware of, that it can't be said that those sorts of consensual disposals of judicial review cases in which the public interest has a role to play are done behind closed doors. They're to be done with transparency. Next slide, please. So what needs to go into a statement of reasons? Well, this isn't prescriptive, obviously, but the guide advises as follows. That the proposed order is by consent, that each legal representative has signed it, and if the order is to finally determine the claim, the manner of determination, i.e. that the claim is being withdrawn or that the decision challenged is quashed. Now that's sometimes a bit of a sticking point, because if all you were going for was a reconsideration of a decision, then it doesn't seem to me illogical to provide in an order that the decision is quashed. And in my view, it can be misleading to see that a decision is being withdrawn, particularly where there hasn't been an acknowledgement of what the legal error was. And that's once again, the importance of the statement of reasons, setting out that legal error so that you're protecting your client from simply having it repeated on any subsequent decision. Next slide, please. Okay, so I've cited there the Mr. Justice Fordham decisions that I've referred to. and a pithy observation from him there about the importance of the open justice principle. So what you have there is a toolkit. When you get a letter from your opponent's solicitor saying, actually, we're going to withdraw, we're going to reconsider this, we don't think this should go to court, we're having a look at this again. This gives you a toolkit for explaining to them, actually, it's not as simple as that. It's certainly not unilateral. Question, is it possible to read across this process to the upper tribunal in its judicial review function? My view, it should be. Obviously, this is something which is reflected in the practice directions and the various regulations and rules in respect of the upper tribunal. However, in my view, exactly the same public law exigency applies. That is to say, the public needs to know and have access to transparent disposals, particularly involving important matters concerning the human rights of individuals who, where the Secretary of State may be conceding that they've acted, the Home Office has acted unlawfully in respect of those individuals. So I can't see any distinction. So my view would be, obviously you can take it up at user group meetings and that sort of thing, but my view is that when you're presented with a consent order by your opponent in the upper tribunal, there's no reason in principle why you shouldn't be urging upon them a statement of reasons to be agreed in the same way. Next slide, please. So the other point I wanted to raise is about the CPR change. Practitioners no doubt will be familiar with the scrabble to get something into the administrative court before they make a decision on the papers, where you've had a particularly egregious pile of nonsense submitted in the as part of the AOS, and the court has now recognised that actually it's quite helpful to have the most egregious submissions made promptly and succinctly corrected on the papers before they have a look at whether permission should be granted at the paper stage. So this is what that procedure now formalises. There are a couple of points really to look out for, though, and that it's not to be done as a matter of course. In fact, the terminology of the PD, which I'm going to come to, is pretty much aimed at dissuading anyone from doing it, but obviously unless it's in a meritorious set of situation. Of course, it may be, and I was just discussing this with my colleagues earlier today, that a change of direction from the top of the government legal service, the Attorney General, may mean that it's less likely that we're going to come across particularly egregious piles of nonsense going forward. And that's because I understand, having heard as much at a speech given by the AG last night, that the intention is to withdraw, if it hasn't already been withdrawn, the previous Attorney General's guidance to government lawyers on litigation risk, and replace it with something which reflects somewhat more enthusiastically the rule of law. So, I mean, that's obviously yet to be seen. Encouraging words, I'm sure. But in the meantime, what should you be looking at? First of all, the new Rule 54(8)A, where you've had an AOS in accordance with the rules. Any reply, that's to say, it's not mandated, is filed not more than 7 days after the service of acknowledgement of service and served on the defendant and anyone else who had the claim form. Time limits under this rule may not be extended by agreement between the parties. Watch out for that. That's the normal rule which applies in public law proceedings, where it's the court that manages time limits and not the parties. And then turn over the page, please, Anusha, to the PD. A reply should be filed only if necessary for the purpose of the court's decision to grant permission. For example, where a discrete issue not addressed in the claim form is raised in the acknowledgement of service. That's pretty much the guidance that we have already had from the court informally. Now it's been formalised. Reply shall be as concise as possible and should not exceed 5 pages. And finally, watch out for this. If you do decide to file a reply unnecessarily, the court may make any order it considers appropriate, whether as to costs or otherwise. A terrifying thought. So those are that's what I was planning to go through today. We've now got some time for questions, and I'm just going to go into the Q&A where we have one question. And it's a Ms. Nike of Council who's letting everybody know that the Secretary of State has PTA in Roundfall. And I'm going to hand that over to Irena to deal with.
Hi, thanks very much, Amanda, and thanks, Sonali, for bringing up the PTA, permission to appeal to the Court of Appeal. You've also asked, are there any news on the individual relief that was granted in that case? And I've been, I'm sorry, I haven't been able to find that information out for you. Maybe the other members of chambers, I know that Steph is acting in the case, and I see that Amanda's keen to speak. Amanda, do you know?
No, but
sorry.
It's I don't know about that, but I'm just observing that one of the reasons that EOG failed, that was the what happens to victims of trafficking, particularly ones that have made been referred into the NRM while they have leave, and then that expires. Whether that's 3C leave or others, but it was the problem of not being able to evidence the fact that you had 3C leave was part of that case. And the Court of Appeal were very, very clear. I think it was Underhill, Lord Justice Underhill, saying, well, that should be something which ought to be sorted out administratively straight away. I'm a little bit disappointed and surprised to see the government saying that actually they would rather not sort that out. But yeah, that's all I was going to add on that. What we can do though is make some inquiries about individual relief and circulate that. There's a second question here from Anonymous, and Anonymous asks, where the respondent agrees to withdraw the impugned decision and then the claimant withdraws the claim and did not ask for the decision to be quashed, can the respondent still rely on the withdrawn decision, or can the respondent still rely on the withdrawn decision in future in law? I take it that you mean by applying the same reasoning to other cases. I'm going to hand that over to Matt, because I think that's right up Matt's street. What do you say, Matt?
I was trying to think through an example where that might happen, because I suppose in practice, if it's a case where maybe you've issued the claim, but effectively the respondent has conceded that the decision in question was unlawful, then in practice you're effectively you'd be putting the court on notice that you're effectively discontinuing, aren't you? And you might be explaining why, and hopefully the respondent will have, or the defendant would have, filed an acknowledgement of service in which they indicate that they are not contesting the claim. But whether they could then rely on the withdrawn decision in future, I mean, I suppose it's.
I think you're in trouble.
Yeah.
If you haven't identified what the error of law is, I mean, they might say, well, we just withdrew it for pragmatic reasons, for whatever reason. This is why statements of reasons are so important.
Yeah.
Because if you haven't identified what the error of law is, then the error of law can be repeated, because they couldn't say it's in bad faith because they hadn't conceded what the error was. I mean, that does seem to me to be the nub of it.
Yeah. I mean, I think, and sometimes you do get cases where the court grants a remedy, they tell the public body to go and reconsider, and then they come up with the same decision but for different reasons. So that's a slightly different thing, isn't it? But then, yeah, if they're just saying that, if they've accepted that the decision was unlawful but they haven't said why, then yeah, as you say, it kind of underlines the importance of the stuff that you were talking about in terms of consent orders and statements of reasons, and yeah, keeping the court up to date as to why a case might be being discontinued or why it's not being contested where that's possible.
Yeah, I mean, I definitely think that this is what Fordham J is getting at. It's all very well withdrawing a decision, but if you haven't nailed down what the error of law is, in fact, there's I think there's a case called Serrano dealing with whether cases are academic, and I think this whole issue overlaps with whether cases are academic or not. And I think that it's important to to remember that even where the Secretary of State withdraws a decision, if they haven't conceded why they're withdrawing it and on the basis of what error, your case may well not be academic at all, particularly if your challenge is one on a point which is going to affect third parties. Slightly different if it's restricted to your own situation and all you were going for was a reconsideration. Right, we've got another question here. Did they give at the end a mandatory order in Ramphal? The judgment ended saying that submissions on mandatory order were invited. Yes, well, I don't know the answer to that question. I don't think Irena does either, but what we can do is try and find out the answer to that question and get it sent around when the slides go round. And then we've got a question here from Matthew McFeely. Any experience of the court in fact exercising its discretion under 54A 8A 7.2? How worried should we be about filing a reply? My own experience thus far is that the court has not complained as long as the reply is short and to the point, but would be interested to hear if others had differing experience. Well, it's early days, Matthew. I don't know. I certainly haven't. I mean, I've submitted a lot of replies over the years, but I always have kept them short, and I've never been criticised for putting in a reply on the basis that it's at the tolerance of the court rather than under the rules. But I certainly think that if there develops a practice where people just shove in a reply which doesn't really have proper justification, I can anticipate that being referred to the Hamid jurisdiction or unpleasant things happening. What do we say to you?
Hi, Amanda, if I can just jump in. I mean, Matthew, I wouldn't be worried. I'm very much with Amanda on this. I wouldn't be worried about filing a reply as long as the reply is necessary, short and to the point. So I don't think you should be put off at all by doing that. It's a reminder, as it were, to make it helpful rather than unhelpful to the court.
And that's from a judge. So do we have any more questions? I'm just looking at the time. It's 2:10. Okay. Regarding the judgment in El Kundi and Imam, is the case that public bodies can use lack of resources as a defence if they can provide satisfactory explanation and support the position with appropriate evidence? Matt, this is one for you, I think.
Yeah, and I was looking at the one from Muna as well, which is on a sort of similar theme. So I'll try and tackle them both. So what I take from Imam and Croydon in particular in terms of lack of resources is that if that is cited in general terms, then the court should be cautious about refusing relief, basically. So I think it will always come down to the evidence in terms of what steps have actually been taken, and the ability of whatever public body it is to actually comply with an order that the court might be minded to grant and what it's being asked to grant by the claimant. So which I realise is a total lawyer's answer in terms of saying, oh, it's always very case by case dependent, but that is going to be the situation. And I think so far, I'll put it this way, I have not seen yet a local authority provide what I would characterise as convincing evidence that is the reason why that's not happened, at least in terms of, a witness statement explaining what steps they've done and why it's so difficult with the resources that they've got, as opposed to what you tend to get, which is much more sort of general pleadings in terms of lack of resources. And on a similar point from Muna, really interesting question about whether the Secretary of State should be invited as an interested party. I think my instinct is that I'd be reluctant to invite them as an interested party, purely on the basis that they're unlikely to be affected by the remedy that your client is going to be seeking in these types of cases, and that is usually the acid test for inviting an IP to be joined. May be more helpful as a potential intervener if you think it's going to help the court to decide the issues before it. But from a claimant's perspective, I think I'd be reluctant to extend such an invitation because the evidence that the Secretary of State might supply might not necessarily be helpful to a claimant's case in that type of situation. But I've noted the kind of your sort of your second sentence about the Secretary of State saying that judicial review is not the medium to illuminate whether more funding is needed for local authorities, which I think is probably right. I think the court might well be reluctant to come to a view as to whether there's enough money in the pot for various things. But yeah, I think I'd certainly be a bit cautious about the idea of an interested party, because if they're not affected by the remedy that your client's seeking, then that probably won't meet the test. So I hope that's helpful. But I think it's a really interesting thought, particularly on the evidence point.
I was wondering whether a sort of a discrete category of case in which it might be beneficial to bring in the government department would be where there's a disputed duty on
Sure, sure. And I've had a couple of cases where, for example, in an asylum support context,
yeah.
the Secretary of State basically said, "Oh no, it's not our fault. It's the fault of our contractor who provided this manifestly unsuitable accommodation." So we had them as an interested party, so they could just blame each other, and that went quite well, because the court was able to be satisfied that yes, the duty had been broken. So yes, where there's a dispute as to an obligation, then sure, but where, as in, you know, in most cases, it's pretty clear cut that a obligation has not been complied with, then I think that is a bit different, because the obligation is usually quite clear who owes the obligation.
Yeah. I mean, sometimes, I mean, you can be a bit of a hostage to fortune, can't you? But sometimes it's helpful to get a bit of accountability where you've got a position being taken by a third party which is causing a problem, but there's no justification for it, or that there needs to be justification.
Yeah, I mean, that came up in the two education cases that I put on the slide. So in both LC and in HXN, both local authorities said that there's an issue with third-party suppliers of whatever was needed. I think tutors and particular types of education provision and so on. But the court was quite clear that in those cases, the evidence just wasn't good enough, that enough proactive steps had been taken to implement the HCPs.
Right, thanks, Matt. I'm noticing that Amy has very helpfully posted the order, which the Ramphel order. I haven't opened it myself, but I'm sure we can circulate that. And we've also got a question about whether the slides are going to be sent around, and they are. So it's now 2:15. So I propose to end the webinar with great thanks to everyone. A couple of things I need to remember to say, which is to say thank you to everyone for joining us, that there'll be a feedback form that pops up, and that we will send a link to both recording and the slides. Thanks very much, everyone. Particular thanks to the excellent presentations from Irena and Matthew. Thanks a lot.